So if the public actually sees statistics that, for example, abortion is dramatically increasing, or that more women are being harmed from the side effects of abortion, or that it's particularly poor women in disadvantaged circumstances, or women who have troubled relationships that are turning to abortion, these kind of data points can move public opinion away from the lie that abortion is this safe, personal, free choice that women are making because they want to. We in the pro-life movement who actually follow this stuff know that that's not the case. Women are often coerced. The side effects, physical as well as emotional, psychological, spiritual, are vast. But when there's no data about the number of abortions, the side effects, the dangers, it's much easier for the public to be deceived about these lies, that abortion is not a big widespread issue, that it's safe for women, and so on. Welcome to the Napa Legal Podcast. I'm Frank DeVito, Senior Counsel and Director of Content at Napa Legal.
And I'm Joseph Clement, Content and Program Manager at Napa Legal.
Great. Thank you for joining us for another episode of the Napa Legal Weekly Podcast. We're starting up front here. If you enjoy the content we're putting out, we appreciate it if you like and subscribe to the podcast and to our channel on YouTube, on Spotify, wherever you're listening from. It really helps us to be able to continue doing this if the people who are listening are taking those little steps to support the work that we're doing here. So thank you in advance. This week, we have a couple interesting and very timely issues. We're going to start with the Supreme Court's decision last week to weigh in on the Fifth Circuit ruling in the abortion pill case, Louisiana versus FDA, that we covered last week. Then we'll talk about a religious freedom lawsuit concerning management of religious property in Indiana, which is a really interesting one. And then we'll finish with a quick coverage of a recent decision by New Mexico to stop tracking abortion data within the state. So to start off, we'll talk about this Louisiana versus FDA case. Now, if you remember, we covered this last week, just in case you didn't listen to that or you don't remember. Since 2016, the FDA, the Food and Drug Administration, has been cutting back on basic medical safety requirements for the administration of the abortion pill, especially mifepristone. First, that was by limiting the number of in-person doctor visits required before mifepristone could be prescribed. It used to be 3 in-person visits, and then in 2016 it was cut down to 1. And then more recently in 2023, during the Biden administration, the in-person visit was eliminated altogether, which paved the way for mifepristone to be prescribed and mailed, including across state lines, without any kind of in-person medical visit or monitoring. That 2023 regulation also did away with a lot of the tracking of the side effects of mifepristone on women. So the practical problem that led to this lawsuit was, of course, that this decision nullifies the state bans on abortions that are currently in effect in many states, including Louisiana, because the drug can just be shipped across state lines without oversight. So even if a state like Louisiana has banned abortion, including the chemical abortions via mifepristone, there's really no way to stop it because you can just have it mailed from a state where there are no abortion restrictions. So the lawsuit was brought by the state of Louisiana. There was also another plaintiff who intervened and came in personally. After the district court ruled, the Fifth Circuit came in just a couple of weeks ago and ruled that removing the in-person requirements violated federal law, overrode state sovereignty. There were some problems with the actual administrative law, the way that the rule was rolled out. There were a lot of issues with it. So the Fifth Circuit stayed the rule, which effectively reinstated the in-person requirement before mifepristone could be prescribed. So we covered this in last week's episode. The Fifth Circuit decision effectively stopped the 2023 rule. But then immediately after, right after we hit record on this podcast last week, the U.S. Supreme Court issued a temporary administrative stay of the Fifth Circuit's ruling. So that briefly put the pause button on the Fifth Circuit's ruling while the Supreme Court justices consider the case. One thing to note quickly, I know a lot of pro-life advocates were dismayed by this. The optics look bad to see Justice Alito come in and say, we're stopping the Fifth Circuit's ruling, and so, mifepristone for the time being can be mailed. It looks like a loss for the pro-life cause and for the rule of law in a case like this, but it is a pretty common administrative procedure when there's a ruling from a circuit court like this that would have a nationwide administrative impact for the Supreme Court to hit pause and decide whether they want to weigh in because it's a national legal issue. And so the national court would make sense that they would want to take a look at it. So practically, where are we? Well, we are recording this episode on May 11th, and unfortunately, we are going to be out of date already because at the time of recording, the stay from the Supreme Court is in effect on the Fifth Circuit decision. That's going to expire by 5 p.m. today. You're going to be listening to this on a Tuesday when the Supreme Court will have already either had to have taken action or just let the stay expire. So it is likely that there will be a further update. We will be updating you in our weekly email that should come out tomorrow. We'll make sure that we cover whatever happens this afternoon and evening. But just a quick note on what could happen. Because again, this was one justice has supervision over issues like this in a particular circuit. And so Justice Alito looked at it and decided that the Supreme Court was going to temporarily stay it and figure out what, if anything, they were going to do. So the responding parties had until last Thursday to file responses with the Supreme Court, weighing in on how the Supreme Court should proceed. And so by the time you're hearing this, the Supreme Court will have to decide one way or another whether the stay remains in place. It's worth just pointing out there are a couple things that they could do. In my mind, the best case scenario would be for the Supreme Court to actually say, we've looked at the responses, we've decided that there's no good reason that the Fifth Circuit's stay of the 2023 rule should not remain in effect. And so the Supreme Court could just take no action. And if they do that by 5 p.m. today, the Fifth Circuit decision written by Judge Duncan will just go back into effect, and the in-person visit requirement will now be required, right? Because the 2023 rule will be stayed. That's possible. It's also possible that the Supreme Court on the emergency docket will do something, will actually weigh in on this issue. And if so, we'll probably hear about that very shortly. It is also possible that the Supreme Court, whether they decide to let their stay expire, to extend it, to do some kind of emergency action, they also may decide to grant cert and hear the full case on the merits, and you can do that on an expedited level. So given the prominence and the importance of this issue, it is quite possible that SCOTUS will say, yeah, no, actually, we want briefing and we want oral argument on this, and we're going to decide this on a fast-tracked, not emergency docket, full docket, but quickly. It's happened before. I wouldn't be shocked. But again, in my mind, just letting this day expire and saying, no, on further reflection, we're going to let the Fifth Circuit's ruling stand would, I think, be the best case scenario. So unfortunately, we had to get this recorded on a Monday. So we will keep you updated as soon as possible and follow this case really closely. Joseph, I know you have a couple of thoughts on this as well. So feel free to kind of color what I've said here.
Yeah, so just one quick thought too on it being a little bit surprising seeing Alito's name on, somebody who's not as familiar with the inner workings of the Supreme Court. Seeing Justice Alito puts a pause on a pro-life ruling could be surprising, but like you said, it's pretty standard. It's also normal for these types of applications for the justice who receives the emergency application, because it's their kind of jurisdiction, I guess, is the one they're responsible for. They typically send this along to the rest of their colleagues and the other justices to say, hey, what are we kind of going to do here? I think in Mirabelli, Justice Kagan actually was the one who received the emergency application, and she ended up voting in the dissent. So this is no indication about Alito's particular thoughts on this matter, but just the fact that he was the one who oversees the emergency applications from the Fifth Circuit. That's why his name is on it. And since we've already covered this so many times, I'm able to really dive into one particular little line that I really liked. So in Judge Duncan's opinion, that was the circuit level opinion that basically ruled against the FDA's dropping the in-person requirements. He wrote two sentences that I really liked and just want to point out. So he wrote, quote, "The public interest is not served by perpetuating a medical practice whose safety the agency admits was inadequately studied. Indeed, the public interest demands the opposite." So to put this in other terms, the common good demands following the evidence regarding the safety of a medical procedure. And I think that precept and that principle, obviously I put it in slightly different terms, but it's basically the same thing that he's saying. I think that's a clear principle, and that most people would agree with that concept, that the common good demands following the evidence on the safety of medical practice. And being truthful to this precept throughout our laws would lead to taking the value of unborn life much more seriously across the board. Scientific research, really even dating back to the Roe v. Wade era, some attorneys from Texas in Roe v. Wade had a great explanation of, even back then in the 70s, scientific research makes it very clear that human life begins at conception. And even today, this isn't really debated anymore. That's not really the problem in pro-life versus pro-abortion. It's not really when does human life begin. It's something else at this point. So if that is true, that human life begins at conception, and that the medical evidence suggests that, which it is true, then a practice that directly kills that human life is certainly counter to the evidence regarding its safety. So just put simply, medical evidence makes it clear that abortion kills an innocent human life. Taking seriously the notion that we have to follow the evidence regarding the safety of a medical procedure means that abortion cannot be protected. So I love Judge Duncan's call here to promote the public interest. I think the principle that he described is true and applies universally. And really, I'm hopeful that if the Supreme Court decides to make a serious decision on this, that they're faithful to that notion.
Yeah, one other thing I would note too is that, and we'll touch on this in the New Mexico case that we'll talk about briefly at the end, but I think there's definitely a narrative issue behind this, right? The supporters of abortion have an important vested interest in making sure that there's an appearance that abortion is this safe, harmless, legal procedure that is really nobody else's business. And, any chink in the armor of that story is a problem, which is why I think you see such vicious opposition to abortion pill reversal, for example, or opposition to an in-person doctor visit before you prescribe mifepristone, because the more you see restrictions like this, the more it becomes obvious in the public square that this is not just some safe, harmless procedure that people can do from the privacy of their own homes. Like this isn't just pro-lifers trying to restrict abortion access for the sake of not having abortions, laudable as that goal is, but it's just real. I mean, the number of women that get sepsis or that hemorrhage from taking mifepristone is not insignificant. It is a significant number, but if we can keep pointing that out by requiring doctor visits, by showing research that this is in fact a danger and a real problem, it undermines the argument that abortion is just this harmless thing and that we're making a big deal out of it. Obviously, that's not true, but pro-abortion supporters have every incentive to try to hide those things. And so I think it makes sense that they would have this huge fight to not only flood pro-life states with mifepristone, but also to cover up the idea that, of course, an in-person doctor visit is appropriate when you're giving somebody a dangerous drug.
Yeah, I don't have the numbers right in front of me, so it might not be the exact percentage, but an FDA study showed somewhere between 2.5 to 4.5 of instances in which a woman takes the abortion pill has like serious bleeding or an adverse medical consequence aside from the killing of the unborn child. And that's even with the in-person requirements. So now that they've dropped them, those numbers will definitely not go down.
Yeah, I saw the number that I think was related to the Fifth Circuit case was 2.6 to 4.9% of women who take it. I just saw something from one of the pro-life organizations who weighed in after the stay that said if you include not just hemorrhaging but sepsis and all the other serious complications, it might be as high as 10%. But either way, clearly not a one-off. These are statistically significant numbers of women harmed by these drugs. Not to mention, the babies being killed by it.
Yeah, it's very sad and very true. So with that, we'll move on to our next update where we'll discuss a religious liberty lawsuit over a Catholic church's management of its own property in Indiana. So the facts in this case are pretty unique. We'll spend a moment unpacking them. So there's this Roman Catholic parish called Holy Cross Church in Indianapolis. Due to financial constraints, it merged with another parish called St. Philip Neri in 2019, and the physical building of Holy Cross Church has been closed and out of use since that time. So in order to follow canon law, which requires local church authorities to safeguard churches from moral use as long as the buildings stand, even churches that are no longer in use and deconsecrated, that is still binding. The Archdiocese decided to demolish the building at Holy Cross Church. So it was a difficult decision. It's always very sad, especially as a Catholic, whenever a church gets closed down. But its leaders, the Archdiocese and the bishop there, felt that it was the only certain way to fulfill their religious obligations in accord with canon law. Now, I'm not a canon law expert, but I do want to spend a brief moment explaining what canon law requires for churches that are no longer used. And I'm pulling largely from an amicus brief filed in this case by a priest at Notre Dame via the school's Religious Liberty Clinic. So, as I understand it, and as the brief there explains it, canon law states that when churches, quote, cannot be used in any way for divine worship, diocesan bishops may relegate them to, quote, profane but not sordid use. Profane meaning secular use. So basically, when a church isn't being used, when a church isn't able to be used for religious worship anymore, the bishop that is overseeing that property has to make sure that it is not put to sordid use. Now, what constitutes a prohibited sordid use is a religious determination entrusted to that bishop. Canon law doesn't have any precise information or precise definition of sordid. It's up to the religious discretion and determination by the local bishop. And a note on demolition. Demolition is generally considered to be a valid way to satisfy this requirement, not just for churches, but for other sacramental items. For example, the USCCB explains that when an altar, quote, can no longer be used, kept for sacred use, the first and best option may well be to bury it in blessed ground or to destroy it in some manner and bury the remains. So basically, demolition and reverent treatment of the building's remains are widely seen as an appropriate and even potentially in some circumstances the ideal method for handling these sorts of things. So coming back to this case, the issue and the dispute comes up when Holy Cross Church was designated a historical location by the city in 2024. And because of this, the city denied the Archdiocese's request for a demolition permit. And instead, the city said that the Archdiocese must either sell the church or maintain the building themselves, which costs roughly $8 million per year. So over this dispute where the Archdiocese says we want to demolish, and the city said you're not allowed to because of this historical designation, that's where this lawsuit comes up. The parish and Archdiocese filed a lawsuit claiming that the Church Autonomy and our LUPA protect their right to make internal religious decisions free from the city and government interference. So as far as where this lawsuit is at now, it's still in the early stages, it's at the trial level, but the judge recently denied the city's motion to dismiss the case, indicating that it's at least going to be heard on the merits. And the main claim here, like I mentioned, is church autonomy. And really the core issue is that the decision to demolish the church building is at its root a religious determination. Church law requires local bishops to safeguard a church property that can no longer be used for religious worship. In this case, the local bishop determined that the best way to fulfill this religious and moral obligation is to demolish the building in accordance with that canon law. Here, the city is attempting to override that determination. I mentioned before, as a Catholic, it's always sad when a church closes down, and I can certainly understand the desire to keep it up, especially when the church itself has a historic value. But what's happening here is the city is ignoring the religious nature of the church and attempting to assert civil control over a religious matter. Yes, the building has historical value, but more than that, it is a church building. It is under the guidance of the Catholic Church and the bishops who have made this religious determination to demolish it. Essentially, what it comes down to is it's not the role of the government to claim a greater civil authority over a religious institution than that of its religious leaders. Just to illustrate this point, as noted by the judge who denied the motion to dismiss here, there were a lot of normative statements about the religious validity of the Archdiocese's decision to demolish the church. One member of the commission, when they were debating what to do with it, doubted whether destruction of the church actually fulfilled canon law. Another argued that putting control of the church into the hands of the bishop, as opposed to a larger group of people, quote, isn't going to hold a lot of water. So these are clearly religious statements and determinations that the city's commission is making. And the First Amendment requires these religious determinations to not be made by civil authorities, but by the appropriate religious ones. And just one other quick point on why the sale of the church could in this instance be not a feasible way to satisfy canon law. Basically, the city is saying that the bishops can just sell it and still satisfy their moral obligations. But really, that can fall short for three reasons. For one, as detailed by that amicus brief, courts are often very hesitant to enforce agreements that say this can only be used for particular uses in the future. Basically, if the bishops sell it to a secular group and they say you can only use this for things that are not sordid and this is how we define sordid, courts are pretty hesitant to actually enforce those. Actually, just last year, the Hawaii Supreme Court held that the state's constitution precluded this exact type of thing. A church sold its property and said you can only use this for church purposes, and the Hawaii Supreme Court said that doesn't actually bind anything. And two, even if a court does bind it, that doesn't prevent future sales to other groups that would put it to sordid use. If you say you can't use this for sordid uses, but then they sell it to another person, that's no longer really binding anymore. And lastly, that still completely misses the point of this actual dispute. This is a religious, not a civil determination. It's not up to the city about what happens to this church. It's up to the Catholic Church who owns it. So to close, I think this is a case that provides a great opportunity to show that there are separate spheres of authority, religious and civil. When civil authorities try to take something from that religious sphere, that runs very contrary to our country's laws and traditions, which favor and must continue to favor the religious leaders. And I'll just close with a quote from this amicus brief that really illustrates this. Whether a religious obligation exists and how the faithful ought to fulfill it are obviously matters of fundamentally religious concern that are the heart of the First Amendment. So yes, it's always tragic as a Catholic when these churches get closed down, regardless of any debate you can have about the bishop's decision. The fact of the matter is it's a religious determination, and it's not the role of the city to try to supersede that.
Yeah, I just a couple of things, right? So there's the separate spheres of civil and religious authority are obviously real. There is a way for them to cooperate and work together, right? We've seen this throughout our nation's history. It is not a wall of separation between church and state, but there are certain spheres of autonomy. So I would just say that, again, it's legitimate to have these historical landmarks and for cities, states, whatever, to preserve them. And it's also just completely inappropriate the way they're going about doing this, because it seems to be completely antagonistic to the religious purpose of the building, which is ironic because the historical value of the building is religious. Like, I don't really see the purpose of like, well, this is a historic building, so if we can turn it into a bar or a brothel, whatever, then that's a significant way for the state to preserve this historical monument. Like, no, it's not. It's historically significant as an old church, not just as a building in any form. Anyway, that's a little bit of an aside, but so there's an appropriate way to do this, which is for a government to come in and say, okay, we understand that you can't afford to maintain this as an active church. We want this to be a historical site that we protect. What can we do to help preserve it in a way that doesn't contradict canon law and the religious doctrines of the church that holds the property, right? Maybe there's this, an endowment, a program, a funding possibility where you make it, a museum of the religious history of that area in Indianapolis or something like that. I don't know. I'm just spitballing here, but the inappropriate way to do it is say, you don't get to decide what to do with this building because it's historical property. If you won't keep it open at your own expense, then we're going to force you to do whatever we think. That's an inappropriate overstepping. And the only other thing I'll say is I think this, to me, seems like a real misstep from the city in the way they tried to undermine the religious considerations of the bishop. If you're really going to go at this and stick to your argument of either the church is going to have to maintain this building or we're going to force a sale because we're not going to allow it to be demolished, fine, but just kind of stick to your arguments that this has historic value. We have a government interest in not letting the building, be destroyed. If the church wants to use their religious autonomy and teaching, that's fine. They can either sell it to someone they think is appropriate or they can maintain it themselves and just leave it at that. But I think when you start to come in and undercut the bishop's religious judgments about it, I think they've actually really damaged their own argument because I think that actually the city's argument against the bishop's reasons really just strengthens the church autonomy argument. So I'll be curious. Again, this is early stages in litigation, but I'll be fascinated to see what goes on. I think the denial of the motion to dismiss is a hopeful sign that this church autonomy argument is at the very least going to be taken seriously, if not prevail. So with that, we'll just move quickly to something that this will just be a brief mention, I think, because there's not a lot of depth to it, but it's a troubling decision and trend. So this is a recent law that was signed in New Mexico that it basically repeals any data tracking requirements for abortions in the state. So abortion is already legal and widespread in the state of New Mexico. There's little to no regulation throughout all trimesters of pregnancy. It is by no means a pro-life state, but we have an added problem here that with the governor recently signing this bill that repeals the data tracking requirements. So basically the state now has no legally enforceable method to track abortions or any of the circumstances surrounding abortions that go on within the state. To be fair, this has already been a major problem with, like we said at the beginning of this episode, the mailing of abortion drugs across state lines without doctor visits, because it's very hard to track what's going on in any state when women are taking these chemical abortion drugs in their houses. You'll often only get the data if they end up in the emergency room. But that aside, this makes it the policy of New Mexico that they're not going to enforce tracking of what happens with abortion in the state. There was an interesting quote from, I think her name is Tara Shaver. So she's a spokesperson for Abortion Free New Mexico, who noted that this bill further divorces abortion from genuine healthcare, which I thought is an interesting point, right? Healthcare doesn't operate in secrecy in this country. She says authentic healthcare requires standards, inspections, accountability, and healthcare does not ask lawmakers to look away, especially when taxpayer dollars are involved, which they often are with abortion. So I just wanted to note that I think a decision like this is a problem both for health and safety reasons and also for policy and pro-life messaging decisions. So I just wanted to briefly note both. On the health and safety side, it's just obviously important to monitor trends like we do with anything. If you're prescribing a new drug, if you're doing a new surgery, tracking helps to see, right, how effective is it? How bad are the side effects? Obviously, you want a shield for anonymity, right? So you don't, it's pretty easy to just redact the names and contact and identifying information of the women who are undergoing abortion, but still track how many abortions were there, what happened, things like that. So these statistics are really important for things like complications associated with abortion drug, associated with failed abortions, the side effects women experience from certain procedures, and so on. This is an important data point, right? They give us a glimpse into the dangers of the act of abortion itself, besides, of course, the killing of unborn babies, but the dangers to women as well. Without such data, it's pretty difficult to oppose certain abortion procedures, particularly those that are unusually dangerous, like we just said about mifepristone, those with high complication rates, because we don't actually know how dangerous they are if nobody's tracking how many women are taking them and how many women are experiencing side effects. So it's a huge health and safety problem when you're taking a practice that is not safe and saying, well, we're just not going to track what happens to people who do it. We have no idea how many people do it. We don't know what happens to them. That's not good medicine. That's not good health policy. I think that's fairly obvious. But on a related note, I think this also creates a policy or messaging problem for the pro-life movement. It's a real difficulty. Right? The public has been led to believe, unfortunately with a lot of success, that abortion is just this safe individual choice. Stop fear-mongering. There are no side effects, or at least they're very rare. Leave women alone. This isn't hurting them, et cetera, et cetera. So if the public actually sees statistics that, for example, abortion is dramatically increasing, or that more women are being harmed from the side effects of abortion, or that it's particularly poor women in disadvantaged circumstances, or women who have troubled relationships that are turning to abortion, these kind of data points can move public opinion away from the lie that abortion is this safe, personal, free choice that women are making because they want to. We in the pro-life movement who actually follow this stuff know that that's not the case. Women are often coerced. The side effects, physical as well as emotional, psychological, spiritual, are vast. But when there's no data about the number of abortions, the side effects, the dangers, it's much easier for the public to be deceived about these lies, that abortion is not a big widespread issue, that it's safe for women, and so on. So laws like this are bad news. Like I said, this is already kind of common with abortion pills being mailed, that it's very hard to track what's happening, especially because the 2023 FDA regulation, right, not only allowed it to be mailed across state lines without a doctor visit in person, but it also got rid of a lot of the tracking of side effects of the abortion pill. So those have not been tracked for a long time through federal regulation. But these kind of laws at the state level that are just explicitly saying we're not going to track abortion data really hinders the pro-life movement, both from tracking health and safety data points, but also from exposing the dangerous truths surrounding the lies that are prevalent from the abortion industry.
Yeah, thanks, Frank. I want to pick up on that logic from the state level pro-life leader. You talked about how there's this divorce of this law, which divorces abortion from actual healthcare. And this really is another of many examples where, although its advocates call it healthcare, abortion is given less stringent medical requirements than actual healthcare. New Mexico state law requires doctors to report a very long list of medical happenings. For example, they have to report drug overdoses, firearm injuries, fractures due to falls among older individuals, any condition identified through genetic screening in newborns. There are very detailed requirements for cancer treatment and reporting infectious diseases, especially those coming out of hospitals. Patient care reports are required for basically anything an EMT or EMS does, emergency services, as well as the patient's medical records. The list goes on. And for potentially good reason, there are many things that medical professionals are required to report on when they perform or identify things, right? If you're performing a risky procedure, it makes sense to have to say what that procedure is and what the outcome was. Now, in New Mexico, abortion is one of the least regulated things that goes on in a hospital. Its legal treatment is entirely inconsistent with the claim that it's healthcare. Healthcare in New Mexico is subject to some oversight, subject to reporting requirements. It's subject to basic medical safety. An abortion is not being treated the same way in New Mexico. And it's very obvious. Abortion is not healthcare. It's certainly bad for the unborn child. It's bad for the mother. Numerous studies show that the serious, like you said, Frank, spiritual, mental, emotional, physical, detrimental effects that abortion has on women, and it's bad for society at large. This claim that abortion is healthcare is clearly a farce because it's not actually being treated comparably in hospitals and by lawmakers as real healthcare.
Yeah, no, that's a great point to end on. Not a hopeful point to end on, but it's important to bring these things to light and talk about obviously the harms and the evil of abortion aside. The lack of regulation and transparency around it just really helps to perpetuate the practice. All right, and we'll also note with sadness that this will be, unless I can get you back as a guest on the podcast, this will be Joseph's last podcast as my co-host as he moves on to. I can talk publicly about this, right? All right, so yeah, Joseph will be starting work next week with our friends at the Alliance Defending Freedom, so we will miss him, but I'm hoping I can rope him in and get him back on at some point. So Joseph, thank you for all you've done for the podcast, and a note to our listeners that the editing quality of the podcasts in the interim may suffer a bit without Joseph to do all the back end stuff. So we will do our best to keep on top of these issues, but you will be tangibly missed from the very first day when I try to record a podcast without you.
It's been a joy getting to do these with you, Frank, and I've loved getting to learn so much, and yeah, it's been really an amazing experience getting to do this. So thank you to everyone at Napa Legal and to anyone that has listened thus far. Thanks for sticking with us and for engaging with our work.
Thanks, Joseph. And with that, we thank you, our listeners. We hope you'll join us next week as we continue to highlight and discuss some of the most important ongoing legal issues that affect religious freedom and the work of faith-based nonprofit organizations. We'll talk to you all next week. Well, at least I will. Thank you for joining us, and God bless you.